Good morning. Thank you all for being here to our conference on environmental health and the law, or the law of environmental health, co-sponsored by the Coleman P. Burke Center for Environmental Law, the Law Medicine Center here at the law school, as well as the Mary Ann Swetland Center for Environmental Health. As you can see, we are doing this as a virtual conference online for obvious reasons due to the coronavirus outbreak. But I think you will see we have a great set of speakers today talking about a wide range of issues relating to environmental health that I really think can inform the discourse about what sorts of policy and legal measures we want to protect environmental health and how to understand the lessons of various experiences we've had before. Just a few quick words about the Burke Center, which is one of the sponsors of this. It's the law school's newest center. It was founded last year due to a gift of $10 million from Coleman P. Burke, one of our alums, to endow a Center for Environmental Law at the law school. And among the things that the center hopes to do is to sponsor and co-sponsor interdisciplinary programs that bring together experts and academics and others from a wide range of fields on matters that are important to environmental law. So I'm particularly pleased that we're able to co-sponsor this program with the Law Medicine Center and with the Swetland Center for Environmental Health, because it's important that we don't just silo ourselves in our own disciplines in developing responses to various environmental problems, whether it's environmental health problems or anything others. We need to be able to talk across disciplinary boundaries. And we hope that this conference will be one step or one example of that sort of initiative. A few other things for those that are watching the video of this conference. We have posted some other online programs that are available for CLE credit for those that are interested. Among our most recent was a lecture by Assistant Attorney General for Environment and Natural Resources, for the Environment and Natural Resources Division, Jeff Clark. That was delivered at the law school, unfortunately without a live audience because of coronavirus, but that was delivered a few weeks ago and will also be available online for CLE credit. And we will be looking in the coming weeks to produce some additional online CLE programs on matters that relate to environmental regulation, as well as the intersection of environmental regulation and public health. I want to turn things over really quickly to my colleague, Sharona Hoffman, who's co-director of the Law Medicine Center, who also wanted to make a few remarks.
Good morning. We are so happy to have you with us, and I hope a lot of people are listening to it after the conference as well. I want to welcome you on behalf of myself and Professor Max Melman, who's the director of our Law Medicine Center. We are the first and oldest center in the country, health law center in the country. We were established in 1953. And we are delighted now to be collaborating with the law school's newest center, our Environmental Health Law Center. And I think this will be a very, very exciting program. We are grateful that you've all been flexible and are joining us in this altered format. We are looking forward to your papers and excited to be publishing them in Health Matrix next year. And we hope that you will have a great day. We are really looking forward to this very interesting conference. I apologize, I'm going to have to leave and teach civil procedure remotely, but I'll be joining later in the afternoon, and I think we are ready to get going.
Great, thank you, Sharona. And later in the day, folks will also be hearing from Dr. Darcy Friedman, who I know is on the call. She's the director of the Mary Ann Swetland Center for Environmental Health at Case Western, and is also a professor of population and quantitative health sciences in the medical school. And we're thrilled that the Swetland Center is also co-sponsoring our program. As Sharona mentioned, I'm going to turn it over to Professor Wendy Wagner to moderate our first panel. She's the Richard Dale Endowed Chair at the University of Texas School of Law. She also, and I think this is very important, a former member of the faculty here at Case Western, but she's a very widely cited and acknowledged expert on environmental risk regulation. Some of her work, including her work on the science trade in risk regulation, is particularly important and is really a leader, I think, in showing how legal academics can do interdisciplinary work. And so I will turn things over to Wendy to moderate our first panel. Where'd Wendy go? There she is. Okay, so I'm going to spotlight Wendy. And Wendy, the panel is yours.
Great. Well, thanks, Sharona and Jonathan, for putting together this terrific conference. Again, I'm sorry we're not live. I am opening the conference with a very timely topic of setting health protective standards, which obviously seems relevant in general and certainly in particular. And when we think about health protective standards, of course, we tend to think about numerical standards, but I would urge us all to obviously think more broadly. We have standards on the books that are broader, including things like social distancing. So in this panel, we're going to get inside this world of how we've been setting health protective standards roughly over the last 50 years in a rigorous way, and see how it's been working at the federal and state level, and how we could also do better. And I think all the panels will probably gesture in that direction. From my perspective, at least, we have a complete dream panel. We have three folks that are nationally and internationally renowned for what they do, and they also span the waterfront of science and law. So I'll introduce them briefly. Each will talk for 15 minutes or less, because I am supposed to be a rigorous timekeeper. And then we'll open it up for some cross discussion and questions. So our first panelist is the resident lawyer, and that's Doug Farquhar. He is the program director for environmental health at the National Conference of State Legislatures. He's been there 25 years. His job entails the entire waterfront of thinking about health and environmental protection at the state level. He advises legislatures, reviews draft legislation. He is really the interface, and also works closely, obviously, with the feds and federal agencies. Prior to going to NCSL, he was in the Texas House of Representatives and actually has his undergraduate degree from University of Texas and his law degree from Denver. Our second panelist is Adam Finkel. Adam Finkel is one of our two scientists. Currently, he's the clinical professor of environmental health sciences at the University of Michigan. Before that, up until 2017, from 2008 to 2017, he was the executive director of the Penn program at the University of Pennsylvania Law School on their program on regulation, which is very well known. And while he was there, he was not only doing science, he also actually taught for 10 years administrative law and regulatory process. He's also been a visiting professor at various places, including the Woodrow Wilson School. Prior to his work in academia, Adam was deep in the trenches at OSHA. He was actually the director of health standards programs at OSHA for 5 years, 1995 to 2000, and also a regional administrator at OSHA from 2000 to 2003, where he dealt with compliance outreach and enforcement. He has his PhD from Harvard in environmental health sciences at the School of Public Health, a master's in public policy at the JFK School at Harvard, and a AB in bio from Harvard. We'll forgive him for all those Harvards, but anyway, that's his background. And our last panelist is Bernie Goldstein. He is also a scientist on the medicine side of things. He is now a faculty emeritus at the University of Pittsburgh Schools of the Public Health, but prior to that, he was the dean at the Graduate School of Public Health at Pittsburgh. But he was also a professor and chairman of the Department of Environmental and Community Medicine at the New Jersey Robert Wood Johnson Medical School. And there he established the largest academic environmental and occupational health program in the United States. Prior to being in academia, Bernie also was deep into the government. He was actually the assistant administrator for research and development at EPA and also an officer with the U.S. Public Health Service. So you can see we really have tapped into a gold mine here in terms of knowledge. Bernie, by the way, has his MD from the NYU and his undergraduate degree from University of Wisconsin. So Doug, we'll let you start. I'll be keeping time, and then we'll roll over to Adam and then to Bernie.
Great. Hopefully you all can hear me. Good morning from Denver, Colorado. Appreciate the opportunity to speak this morning. I am Doug Farquhar. I direct the Environmental Health Program for the National Conference of State Legislatures, where I provide policy research to the state legislatures and have to spend quite a bit of time trying to discuss and educate people at the many levels of government about the possibilities and the limitations that state law has. I'm going to share my screen and hopefully this will work easily. Okay, it doesn't look like I can share my screen. Wendy, do you know how to put up my PowerPoint?
There's a little share screen at the bottom.
And slideshow. There we go. Can we all see that?
Yes.
Excellent. Well, if we are back on again, I'm going to turn over to my first slide here, give you an overview of what policy is. What I consider policy, it consists of the formal set of plans and principles intended to address public problems. It's the tool to encourage or discourage an action or inaction in response to a public concern. Public policies made by the governments on behalf of their constituents, be they local, tribal, state, federal, or international. And the government's ability, the reason we give them the right to do these, to implement these actions, is comes from their authority in the Constitution that their constituents grant them. The public grants Congress, the state legislatures, the city councils, the tribal councils, the authority to impose restrictions on its citizens, and requires certain businesses to act in certain ways regarding environmental emissions that harm human health. This grant comes from four mechanisms: constitutions, statutes, regulations, and the common law. Constitutions, very straightforward. Is the U.S. Constitution is the source of all legal authority for the federal government, and each state has their own constitution, which they can dictate. The key issue about the U.S. Constitution is the term public health nor environment is mentioned nowhere in the Constitution. Much of the federal authority to regulate environmental health emanates from its authority to regulate commerce between the states and its authority to tax and spend. This leaves the primary responsibility for environmental public health left to the states via the 10th Amendment. As with the federal government, state and local governments are limited by their own constitutions. This can range from the manner in which a state adopts tax policy to limitations on regulating private property. Constitutions limit the extent a government may regulate individual rights, or they may expand the authority to the public over the individual. Each constitution provides for the establishment of state and local government powers. Certain states, the local governments have the authority to regulate themselves without interference from the state legislature. Many states, the state legislature has the authority to review every law or ordinance that is adopted by the local government to determine whether it shall move forward. The 10th Amendment, every lawyer has their favorite amendment, and this is mine. The powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively, or to the principals. The Constitution's enumerated powers to the federal government do not include the environment or public health. This means that it's up to the states to respond to this, and this is the point I try to bring up over and over again with the state legislatures. There we go, that looks a little bit cleaner there. Statutory laws, and again, this is a very basic overview of civics, but it's something I've discovered most law students do not learn in their undergraduate. Statutes. Statutes are the laws adopted by the legislatures, either Congress, the state legislatures, county commissioners, tribal or city councils on behalf of the public. This means issues such as the Clean Air Act, the Clean Water Act, the Chemical Safety Act, the Food Safety Modernization Act, are all have to be adopted by a body and adopted as a statute. Legislative bodies either have the authority to determine the rights and responsibilities of actions regarding on their own governmental lands as a landowner, or they can act under the authority of police powers. Police powers are the powers exercised by governments to enact legislation to protect the public health, welfare, and morals, and to promote the common good. Statutes are the laws and policies adopted by the people's branch of the government. This is the people that are elected that have actually very close ties with the people that they represent. The interesting thing I've noticed is that the closer they are to representing their citizens, meaning city councils or county commissioners, tribal councils, the more progressive the laws tend to be. The further away you are, such as Congress or the presidency, the less likely your laws are going to be very progressive. Only point I'm going to bring up with this issue, because I'd like to move forward here, is that when you talk about different bills and different pieces of legislation, legislation has the power of the government behind it. Resolutions are not as strong because they're only passed by one chamber, so they have no enforcement. The appropriations law simply states forward how the state or the government is going to spend the money, its tax money. The good thing about policy that is put into appropriation language is you can guarantee it'll always be enacted. So oftentimes I have seen environmental health laws placed in the appropriations law to make sure it gets moved forward and enacted. Real quick, I want to kind of give very much of an overview about the way state legislatures are set up. Much like you see with the Congress, you got a House and a Senate, and you have an executive. But every state has little nuances that make it either unique to make it easier or more challenging to adopt a law. California, for example, the legislature enacts the statutes requiring state agencies to perform specific functions, but it's the responsibility of the governor to fund these measures. If the governor does not want to fund them, these actions don't occur. In Colorado, the legislature does not have the authority to raise taxes or expand the state government without such actions being subject to a popular vote. Nebraska, it only has one chamber. It has the Senate. North Carolina and Texas, they limit the governor's authority. All the statute and budgetary decisions are made by the legislature in that state. 8 states, the legislatures meet year-round. In 4 states, they meet every other year. Every one of these nuances make it either easy or more difficult to pass a state statute. With the legislative process, the interesting thing here is after you have gone through all this effort, it is designed to really not work, which is one of the interesting principles that the founding fathers have, because it is such a complicated process, meaning it has to be introduced by a legislative member. You have to have testimony on the bill. You have to pass the bill before one chamber before moving over to another chamber to have the same thing happen again. And then after this, the whole thing may be vetoed by the executive. So it's extremely difficult to get a law passed. Adopting a law is a very lengthy process, and the important thing that we often fail to recognize in the public health community is that there are many advocates involved with many stakeholders involved with any sort of law. So even though we may have solid evidence to say we should be doing certain things to promote the public's health, there are also business interests that have different attitudes. They have consumer groups. We have different groups of the medical association, different groups of public health associations. They all have a say in this, and so therefore it becomes very difficult for state legislatures to adopt a single rule or policy, because you have to mitigate the terms of all these different interests. Cooperative federalism. With all major federal environmental laws, these all have been adopted under the concept of cooperative federalism. This entails the state legislature enacting a law that says if you meet the basic provisions of the federal act, federal government will allow a state agency to act in its place in lieu of the federal agency. If the federal government agrees that the state law will be as protective as, or no less stringent than, or at least as stringent as the federal law and provide adequate enforcement, then the federal agency will delegate the program to the state. For a state, for environmental law, the agency agrees not to administer and enforce into the state. Regulations. Very simple and straightforward is that regulations have to allow the state agency to administer the laws. They can, administrative agencies, being federal, state, or local, the power that they have to regulate a law is limited by the scope that the legislature has given to them. This authority is limited also by its constitution. In promulgating regulations, agencies are subject to many of the procedures that legislatures face in enacting statutes. Regulations must be published in advance, provide the public with the opportunity to comment, often provide for a public hearing, and require the agency to respond to the public's comments. Agencies then publish a final rule, which may be challenged by the courts if it fails to meet the scope and authority of the statute of the law that's being implemented. Legislature, federal regulations, regulatory environmental public health agencies are resource intensive. They require staff to implement the requirements of the law, as well as staff to ensure enforcement. Enforcing laws requires oversight of record keeping, monitoring of actions, identification of violations, and prosecution of these actions. So therefore, they are very resource intensive. Non-regulatory agencies, and these are agencies such as the CDC, ATSDR, NIOSH, they are the laws that they are non-regulatory. They provide guidance, they provide research, but they are not anywhere near as resource intensive as the regulatory agencies. Now within this, I want to bring up one final point here, is that the legislature determines the scope and authority of the agencies to address certain issues. Agencies cannot regulate outside the scope of this, cannot regulate issues outside the scope. Agencies promulgate regulations in response to statutory law, establishing the manner in which the law is administered and operated. This setup makes state legislatures inherently conservative. The way a state legislature, the way the Congress is set up, the way that local commissions, county commissions are set up, you have a situation there where a legislator who has been elected by their constituents has to deal with the balancing act between regulating policy that may be for the public's good that is going to inhibit, but will inhibit the individual freedoms. Any state legislature, any elected official who goes too far one way or the other, putting too many restrictions or embracing individual rights too much, are likely to lose their seat. And the number one issue that they try to do is retain their power in office. So with that in mind, you understand that the way that these bodies are set up, they're inherently conservative. And they don't, they're not designed to create new policies, new laws, anything that is outside the norm. So whenever we regulate and address environmental health, it makes it extremely challenging to get a law through. So with that being in note, I want folks to somewhat realize about the challenges that these policymaking bodies have to face, the limitations that they actually have, and to dispel the myth that they're omnipotent and that they can pass anything. They are extremely limited bodies in trying to get things done, and so any movement towards adopting environmental law or dealing with public health issues is extremely limited and done very cautiously. With that, I am going to say thank you. I enjoyed the talk we had this morning and look forward to hearing your questions after all the speakers are done. Thank you.
Okay, Doug, I'm being told I can't share until you stop sharing. Got it, I think. Yep. How's that? Okay, I see Wendy saying, I'm trying to put my slides full screen, but that's not happening yet. One more second. Yeah. Thank you. Glad to well, I'm going to say glad to be here. I'm not here. No one's here. I'm going to hope that the slides are archived somewhere, and I'm going to have to, given the time constraint, sort of use them as visuals and not be able to go through in detail. I'm sorry, but I want to make sure I get some points out, because I thought that Jonathan asked a great question at the beginning, which was, to what extent do these laws and regulations adequately address these persistent threats? I'm going to answer it in the negative. It has gotten worse in the last few years, but I'm taking the 40 to 50 year long view, and my answer would have been the same at any time in the past. So I'm going to talk about 4 reasons for this. On this slide, our methods tend to underestimate risks and overestimate regulatory costs. I say, yes, you read that right, because the prevailing mythos, I believe, spread by untrained, poorly trained people with agendas, is exactly the opposite. You've all been told, I think, ad nauseum, that risk assessment exaggerates and that economics underestimates cost, and both are incorrect, and in fact the opposite is much more largely true. I'll talk briefly, because this is really not for scientists, on number 3. I have some concerns about more recent changes to bias the science and not to admit its limitations. I skipped one, number 2. I want to talk a little bit about what I think are silly policy reforms, in quotes, that exacerbate this costs of inaction exceed the benefits of action problem. And if I have time, I want to talk, segueing on what Doug said, to the issue of agency power and what others, and now I am calling, learned helplessness in the agencies. And if I have time, I want to talk about 2 improvements beyond my agenda of making analysis great again, which would really be great for the first time, that we ought to try to think more about regulating based on tangible human suffering, both physical suffering, disease and death, and economic suffering, rather than continuing always to focus on total benefits and costs, which often are dominated by very small, very diffuse and very inchoate benefits and cost. And then I've been evangelizing for some years, and Bernie's been a great supporter and critic of mine on this, that maybe we should stop dissecting problems so much and put risk assessment in the role more of both comparing solutions, but also proffering more ambitious solutions than we've been willing to contemplate. And I hope to have time for one example of that. So, of course, I could go for hours on the failures of the agencies to achieve their goals over 50 years, but there's no time for that. Here's just one slide from the workplace, which I won't have time to go through, but showing that the OSHA exposure limits for hundreds of substances are so bad and so out of date that in almost every case, whereas EPA has been striving and often not reaching the 1 in a million excess lifetime risk of death benchmark, OSHA is almost always above the 1 in 1,000 and often shockingly higher even than that. I want to be sure to say always that no one should mistake my critique for someone who is a fan of the precautionary principle or critical of risk assessment and of cost benefit. I'm a strong proponent of both of those methods. Here are some quotes from friends of mine, Peter Montague and Andre Carruthers, who have said some very harsh things about what I and others do, and I applaud their zeal, and I think they're completely wrong about the best ways to protect health and the environment and balance that against economic costs. Don't have time to do a teaching moment here, but the precautionary principle can be used or misused by anyone. So this quote in the black type is not from the Wingspread statement or the Rio conference or anything of the sort. It is President Bush's justification for invading the wrong country in 2002. Again, talking about this hoax that risk assessment is conservative. I have some quotes from way back in the 80s and 90s about this, and a lot of what I've been writing about ever since has been showing, I think, fairly compelling way that the methods of risk assessment are full of underestimation, and the methods of economics are replete with overestimation. So here's a slide that someone could look at in more detail later, but in the 2x2 table of ways we underestimate or overestimate either one, the red type are the things that are rarely talked about, and the black type, underestimation of cost, overestimation of risk. They exist, but I would assert that they are in toto not as potent, the biases in the other directions on both sides of the ledger. And here's a compendium from RFF, where I used to work, about over and over again, the ex post costs of regulation are dramatically lower than the ex ante estimates, and there's some very common sense reasons for that. Moving on quickly to policy reform. Some of these are more present day and not so much from the last several decades, but all these ideas on the left column have been out there for a while, and I'll just pick and choose a couple of them. So now we're talking, we've actually implemented a regulatory budget. Agencies cannot impose more than a set number of costs, regardless of the benefits they confer. And what I did as a thought experiment was to say, well, you know, for the next administration, maybe, what if we took all of these notions on the left and just inverted them and made them the opposite? Would they be as ridiculous? And my answer is some of them are ridiculous, either framing, but actually some of the ones on the right are more sensible than some of the ones on the left. If you can analyze and fine tune and design regulations so as to have benefits in excess of costs, then a regulatory budget is completely ridiculous and wrong-headed. There should be a minimal benefits budget. Why would we produce a product that makes a profit on every unit and restrict the number of units we can sell? We ought to be making sure that we're always doing some profit making with this analogy. The bottom one, I think, is useful example. We talk about cost effectiveness. We talk about, and we always only frame it as, let's go for the least cost to achieve an arbitrary amount of benefit. And we call that the the most bang for the buck, but actually it's the least buck for the bang. And if we wanted to do this sensibly, we would be, again, flipping the framing, we would be looking for the greatest benefit possible without exceeding an arbitrary cost constraint. That would be actually literally the most bang for the buck. And I'll skip this one. I really don't want to spend time on the science for this audience, but there's a growing mania about thresholds, all not only non-carcinogens, which some people assert have them, and maybe with some good reason, but carcinogens, which I think pretty clearly don't. But the point I want to make is that whole discussion is misguided because it's used as an input to a public policy and regulatory process, and the only relevant question about thresholds in that regime is not, is there one, but is there one somewhere between where we are with today's exposures and where the agency wants us to be. And so I'll just show you, this is the paradigm visual that people create. There's nothing wrong with it, but look at those three yellow diamonds as the empirical data and all the different ways you can fit threshold and non-threshold models to that. It's really much more like this visually. The data are way up in the right-hand corner and very close to each other. And then the agencies come in and say, and I'm exaggerating a bit by using molecules per lifetime, but they're saying we're exposing people to 10 to the 27th of these. What if we dropped it by a factor of 10 to 10 to the 26 septillions of molecules per lifetime? Fine. Is there a threshold in that very narrow swath of public policy? Maybe, but just to say that somewhere in the 26 orders of magnitude to their left, there might be one, is completely diversionary to what agencies ought to be trying to do. Again, no time to talk about systematic review, but that's another growing fetish in the field. And I have no problem with it other than it's arraying what they say are all the data, but it's got a thumb on the scale that it only looks at new data. It does not look at all of the decades and centuries of data that support the somewhat precautionary assumptions that we've always made, like when you see rats and mice dying of something in the laboratory, we presume that it would happen to humans without compelling evidence to the contrary. There's a database on that that goes back more than a century. No, I'll skip that. I don't have my clock on. I guess I'm about halfway through, Wendy. 5 minutes. Okay, so one of the, I guess I'll say the third thing about science, people talk about hormesis, which is basically the notion that small doses of stressors, chemicals, or others can be good for you. Perfectly valid notion. But again, it's completely oblivious to the world in which we live and that we're trying to intervene through regulation, information, partnerships, and whatever. So here's you can read the text about silly things that people have said about football. Here's the example. We have to balance the benefits of eating fish on brain development with the risks of eating fish from mercury. Sure we do, but the way to do that is not to say eat a middle amount of fish and not be too worried about mercury. The way to do that is to eat varieties of fish that are low in mercury and high in the good stuff. And if you really want to balance that efficiently, you eat very low mercury fish and take omega-3s as a pill. So to move quickly to possible solutions, here's one that's kind of a regulatory in the weeds. I'm calling it a perfect quid pro quo. This resonated more about 6 months ago. While we argue about thresholds and causality and hormesis and all these things that the scientists pretend are value neutral and know that will monkey wrench the system, maybe we should bifurcate and maybe we should try to get some agreement that with the high exposures that we're subjecting people to in the workplace particularly, and the environment to some extent as well, that there's an amount of exposure reduction that would be necessary and moral and efficient under any conceivable scientific verdict about causality and thresholds and so forth. And let's get to there. Let's drop it by a factor of 2 or 5 or 10, and then put that issue back onto the gold-plated highway and wait 50 years for more data about whether those preliminary controls were slightly too stringent or way too lax, and then we could refine. At least that would not hold the good hostage to the perfect. And then 2 more points. Learned helplessness. OSHA is the poster child for learned helplessness, but Jamie Conrad, a former American Chemistry Council guy, said it very well about EPA as well. And the take home here is this horse who is chained, in quotes, by a length of rope to a plastic chair, and the horse has been conditioned to believe that he is trapped and can't move. And that's what we've done. That's what our agencies have done to themselves, in my view. So I have a quote from the Environmental Law Institute magazine on the bottom left. And then my other two, just to wrap up, one policy response, again, would be to try and focus on the high risk and high cost ends of the distribution. And I wish I had time to go through this animation, but again, if you look at the slides, there are 4 cases here: diffuse cost, diffuse benefit, concentrated cost, concentrated benefit. And the green arrows say that under the current dogma of we add up all the costs and all the benefits, even if it's pennies per person times 300 million people, even if it's 1 in 10 million chance of risk times 300 people. The green arrows are what we would say today are benefits in excess of cost, therefore we can regulate. The red arrows are the opposite. And I would say in each of these cases, with one ambiguous result, if we looked at it, how can we reduce the number of people who are quote unquote suffering, either from intolerably high exposures or from unemployment, bankruptcies, et cetera, due to regulation, we would do the opposite in at least 3 of these 4 cases. And then my final point, which Bernie has commented on extensively, is solution focused. Let's take this example. EPA, I guarantee, even when they are replenished and back on their stated mission instead of doing the opposite as they've been doing for 3 years, even when they get there, I guarantee you they will spend the next decade or more construing the issue of endocrine disruptors in water bottles as the endocrine disruptor problem, in quotes. They will set numerical limits for bisphenol A and bisphenol H and a series of other substitutes that come from the plastic into the water, and eventually they will lower the risk of each of those things in turn and keep fighting the new substitutes. No one at EPA has been willing to say the problem really is that when most of us were kids and teenagers, the market had not conceived that people would be buying 50 billion plastic units of water, a commodity that falls from the sky, and spend dollars on it and put 50 billion plastic bottles in landfills with the greenhouse footprint of that. So changing the market to give us more of the function, cold, clean, available drinking water on the bottom right would be, I think, much more profitable than dissecting the problem and dialing down these limits bit by bit. All right, thank you.
Hi, it's Bernie Goldstein. I hope you can hear me. Anybody want to nod and tell me they can hear me? Yes, good, okay. Thank you. Now I just have to put up my PowerPoints. Can you see that? I'm going to hope you can see that because I can't see the PowerPoints and you at the same time, at least for now. And so I'm going to talk. Good. Yes. Okay. So as Wendy basically told you in the introduction, I'm a public health physician, basically, and have inevitably been drawn into the coronavirus issue. This will pass, however, and when it does, we're going to have to still deal with how best to develop and respond to the problems that have been developed under the current administration about developing science-based environmental regulation. That's going to be with us. My underlying thesis, which let's see, I need to go full screen here. Here we go. To get rid of all your beautiful pictures, is that what we're doing under the present administration sort of fits under changing the scientific processes based on consensus to the confrontational process, which are perfectly appropriate for law. And they end up hamstringing the use of science for environmental protection. There's 2 bills that were passed in the House, but not the Senate when President Trump came in. that sort of exemplify a lot of the issues. These bills have been long in development. One excludes EPA grantees from serving on EPA advisory committee and makes more room for industry consultants, and I'll talk a lot about the consultant issue. And the other basically throws out any science published in peer-reviewed journals, replicated by 6 other scientific papers that they cannot get the raw data from, which I will argue is basically to turn over to industry consultants. It's important to understand the role of external scientific advisory committees at EPA. Congress has established a lot of them through the years. EPA leadership has initiated others. The total is now 23, unless some have been abolished in the last few days. And EPA through the years has developed internal processes to select advisors with the requisite credentials and to balance the committee membership. But this is now being distorted. The EPA particularly needs a strong and unbiased external advisory process. By having its own in-house science arm, the agency's political leadership can exert pressure to get the answers it wants from the scientists. As a counterbalance, it is necessary to have independent external advisory processes. Otherwise, the administrator is basically the judge and jury on the science, which is not the way EPA has been organized. So, I mean, why has EPA become so dependent on external scientific advisory committees? And this is my bias as a scientist. And I spent 2 very good years with very good people working under Bill Repko's house as head of the Office of Research and Development. But my impression was that while scientists try to manipulate formulas to match the real world, and if we get the formulas wrong, we'll get a kick in the butt. Policymakers at times try to manipulate the real world to match formulas. I've been putting that on slides for many, many years. I left EPA, it's what, 35 years ago. I thought the formulation by Coleman and Domenici in Science last year, and that's a very good paper about what's happening, is really superb. It's science without policy is science, and policy without science is gambling. Some slides I developed when I left EPA was to try to puzzle through the issue of how selection of scientists sort of changed when we went from the consensus process of science toward the inevitable legal confrontations that occur, EPA getting sued from both sides. And the following 2 slides try to capture the essence of a consensus and a confrontational process. Both presuppose that there are a large number of knowledgeable and unbiased scientists who have a range of judgments. Let's say it's about the no observed effect level for ozone, which would be put into the recommendation for the standard under the Clean Air Act. That if we solicited them individually, it ended up in some sort of bell-shaped curve. What we do instead is put together a committee, in this case, the Clean Air Scientific Advisory Committee, and until very recently, its subcommittees, that will then make a recommendation. As you can see, I've got those 6 X's in there to refer to the committee on a consensus process, and they're put together a little more closely than they would be if it was just a random selection, because what we tend to do and what those arrows intend to show is that we tend to huddle together as scientists. Not always, but we don't want to lose our reputation by being the one person who may be wrong about this while everybody else is off somewhere else. Appropriately, for a legal process, there's a confrontation from the same body of scientists who are qualified to respond. You know, the Sierra Club would, for the ozone standard, would pick the 3 X's on the left, the 3 folks on the left, and the American Petroleum Institute would pick the 3 on the right, and they're all good scientists. I'm not saying that they've sold out or anything like that. What's happening at EPA using this same kind of simplified analysis is basically there's been a change in the selection process so that, as you notice, the X's are more to the right, pro-industry side, if you will, of setting a standard. And one of those X's is actually outside the range of of people who legitimately should be considered an expert under the previous approaches. There's other issues as well. I mean, the chair of CASAC, of Clean Air Scientific Advisory Committee, is someone who's a knowledgeable scientist, an excellent statistician. He could well be chosen to be on the committee, but never as chair. I mean, his previous statements would basically mean that he would disqualify him from chairing a National Academy or similar consensus committee, or CASAC under any prior administration. And let me emphasize, I chaired the CASAC under Ann Gorsuch, and there's nothing at all that Ann Gorsuch tried to do to CASAC, which is even close to what's happening right now. We're under new territory here in terms of what's happening to the science. So where does this come from? Very simply, and I'll go through this quickly, we just, scientists and lawyers just have very different, they're appropriate, but they're very different training. If you have a moot court somewhere and there's some information that's advantageous to the other side, the student who's in that court will lose points if they give the other side's point of view. You just don't show that information in the hopes that the other side won't have it. You're ready to respond. On the other hand, if it's a thesis defense and the student basically says, doesn't tell us about some published data out there that contradicts their thesis, we'll take lots of points off. In fact, they may not even get their thesis. That's not appropriate. An example of that is, I'll skip this. An example of that is the Bridgestone Firestone tire defect. They had more than 270 people die because there was a tire defect in an SUVs. The major law firms handling these cases knew about it, but of course, what you do is to try to get the best for your client. So you basically sign up confidentiality agreements and you get more money and the word doesn't get out. When the word doesn't get out, you end up with a situation which, the head of the National Transportation Safety Board, a trauma surgeon, was just irate about this, as you can read from this. This is, as far as he was concerned, unethical. But I love this guy's name, Professor Hazard, the trustee professor of law at the University of Pennsylvania Law School. The lawyers had not broken any laws or ethical code for lawyers. So this is inherent in that process and that difference. And what we see is basically the legal approach taking it over. What we have with a lot of the changes in the rules as to who gets to serve on the advisory committee and changes internally within EPA of the selection process is it's not so much industry people replacing academic scientists, it's industry consultants who are replacing academic scientists. I hope you all recognize the lawyer I'd certainly want to represent me if he was still alive, if I was accused of a crime. That's Johnny Cochran, who got OJ off from something that I think depended upon his lawyering rather than on the facts. Is there any reason that a defense lawyer is different in the sense of you basically help, as an industry consultant, you help the industry that you've been hired by, and if you don't help that industry by basically looking at the science in their way, you're not going to get hired again. And the same thing's true for the defense lawyer. Well, is it also true for an academic scientist? That's what EPA is claiming. And that's why EPA scientists, that's why academic scientists who've ever gotten money from EPA are automatically disqualified. And those even who've gotten money through NIH, they sort of have a tougher time getting on science advisory processes. Well, what is it an academic scientist risks if he or she gets the science wrong? Their peers who have similar expertise are on these same EPA advisory committees. And if they get a bad, if their impression of this scientist is someone who will go loose with the facts because they've got a bias to start with, this scientist is in trouble because The peers who are on the same committee are those who are chosen to review their manuscripts by editors. They will serve on the studies section that reviews their grant proposal and be asked by their provost for an outside letter related to promotion or tenure. You should not, any scientist should not take the chance of being seen as biased on an advisory committee when their peers are there, because that will certainly hurt their reputations and their ability to move forward in the field. And then there's this wonderful thing on corpuscularization, which Wendy's colleague Tom McGarity talks so much about. And I've seen this, I do some toxic tort work, I've seen this in toxic torts as well. You attack the other side's scientific evidence by finding the slightest lack of perfection in every one of the opponent's supporting scientific papers. And based upon this lack of perfection, you throw each one of them out. But we don't do that in a scientific consensus approach. We'll look at causality or levels of pollutants by weight of evidence, not in any individual study. Well, one question is, why don't we respond to this corpuscularization approach by doing unblemished environmental health studies? Well, the gold standard for epidemiology is a randomized double-blind study used in trials of new drugs. Half of a group of volunteers with, say, rheumatoid arthritis will receive the drug, and half will receive a placebo. Neither they nor their physicians will know which until the study is over. We can do that with a new drug, because the industry is going to spend millions of dollars, and we need complete transparency to be sure they're not faking the data. And so we go after transparency there. But anybody here want to be exposed to a pollutant as part of a study? We don't have that opportunity. What we do instead is evaluate the incidence of an adverse effect in relation to geographic or temporal differences in exposure, and far more likelihood of accidental confounding. We do not do replication of findings through different studies on different populations. I'm sorry, that's how we do the replication of findings. We do it through different studies on different populations, not by reevaluating the same study findings. There's an old saw in statistics about how somebody once read something in the paper and wasn't very sure about it, so didn't quite believe it. So in order to convince themselves and see whether it's right or wrong, they went out and bought 10 copies of the same paper, and by God, it all said the same thing, so it must be right. This is the kind of issue that we have with how EPA is dealing with the transparency thing. They're imagining that we have an approach that's one paper at a time. There's lots of other things I can say. I've cut this down, so I want to talk about two scenarios, two issues which are not quite as well known as the others I've talked about, so I won't be talking as much about CASAC, which I feel very strongly about, or the Science Advisory Board. And these are, one of the scenarios has to do with something that really scared me when I was head of ORD. How would I know, what can I do to prevent the unforeseen event, the unforeseen recognition of some cause and effect relationship? What can I do in advance? And so I want you to imagine that 3 papers are published roughly a month apart, reporting a highly significant observed association between a chemical in commerce and an adverse endpoint, not been seen before. And they're from 3 different countries. The pressure builds on EPA to respond, but none of these international scientists are willing to share raw data with EPA. Why should they? Why should they be hounded by made up blemishes by industry that they have to respond to? Well, what if that happens? What will EPA do? Or what will EPA do if I want to further add to the scenario of that there is a previously published industry study which shows no association between this cause and this alleged effect? Study itself is well done, but it has too little statistical power to confirm or refute the other 3 studies. The rest may have been done on 50 people who were in the workplace, and this is a phenomenon, an endpoint that occurs in 1% of the population. Industry is more than willing to share the raw data. What will they do? Let me give a second addition to the scenario. EPA's assistant administrator for R&D basically gotten word of these studies or maybe thought ahead about this and actually has funded through a competitive process some American scientists to go look at this issue, but they haven't gone far enough to do any peer-reviewed publication on it. Obviously, these are the most knowledgeable people to give EPA advice on how to deal with those findings in those 3 other studies. But because they are funded by EPA, they cannot give EPA advice. I mean, how stupid is that? Let me add another thing. The environmental justice issue, which has been talked about, but I think needs to be emphasized more, about this whole issue of transparency. Again, imagine a disadvantaged community where there's concern about high exposures to a chemical from a local industry. An industry claims the chemical is harmless. EPA reviews the relevant science, but it's got it restricted to just the raw data studies available. The cost of reanalysis of these studies is in 6 figures, probably. An industry can afford to do it, but can the community? Obviously not. So you're setting up something that's unequal. And that brings up the issue of equipoise, which is something that institutional review boards tend to look at. In other words, the equipoise, simply put, is you won't get approval for a study that is designed in such a way that it can only show that women are smarter than men. It can't show that men are smarter than women. It's not an equal thing. You'd have to go to this IRB to get approval to have your study, to turn over your raw data to the EPA, because it's now part of a regulatory process. Will the IRB allow that under the circumstances I gave before, when in fact it's only going to be thoroughly reevaluated by one side of the issue, not the other? I don't know. But I do know that EPA was apprised of this and basically has absolutely refused to ask the National Academy of Sciences or other kind of outside groups to take a look at that puzzling issue. So I'm going to conclude with a digression to bring back to the issue of coronavirus and the environment.
We're
basically,
time. You can go quickly, but
quickly. Okay, so basically, Doug has told you that we do not have in our Constitution the ability to deal with the environment at the federal level or human health, except under lots of constraints. It's clear that the 2 most problematic problems right now are emerging infections, which will continue. We'll get new emerging infections, and we won't wait another 100 years for it. And obviously, global climate change. The founding fathers could not have considered those type of issues when they set up which went to the feds and which went to the states. I think it's time we amend our Constitution.
Fabulous. Thank you so much. If all the panelists could put their unmute. First, wanted to give you guys an opportunity if you wanted to chime in and comment or ask questions of each other. I think that's the first place to start, and we'll see if we have more general questions. And I always have a few. So do any of you, those, but I wanted to know before.
You know, just one point I'd like to bring out after hearing Adam and Bernie is that we see a lot of states adopt standards that are different than EPA. One of the more interesting ones recently is on PFAS, whereas EPA came up with a standard of 70 parts per trillion. They came up with that standard because of all the pressure that they had on them, the different restrictions that they had, the different data that they can use to come up with the standard. The state of Michigan went through the same process. They had just as much data. They looked at the issue. Their standard came up with 5 parts per trillion. That's an enormous difference. It's much more strict than what the EPA came up with. I think what that really represents is the power of the different outside stakeholders and the different influences that gets placed on a standard setting process will dictate dramatic differences on what the standard ends up being.
Any of you guys have a response? If not, I was going to jump in with a question that kind of runs underneath all your presentations, again, which were excellent. I learned a ton, which is each of you are sort of talking in different ways about the intersection between science and law. In some way, Bernie's is sort of emphasizing the political control of science, Adam's kind of highlighting some ways that the scientists themselves may not be explicit, and Doug gives us the architecture. How do we think about this interface as a legal or an institutional matter? So that breaks down into really two questions. I mean, are they essentially institutionally separated in a way where we really know what the experts are seeing? Or is it so intermingled that that creates some of the complications in trying to figure out what the expert world has to offer? It's kind of implicit in what Doug just saw too. And how normatively should we do this if we're kind of messing it up by throwing them together in ways where they both are sort of inextricably contributing to the conversation?
Well, Wendy, let me jump in and say,
with Doug, or Adam, please, you go first.
all right, I was just going to say, we've been talking about the inextricable conflation of science and policy for a long time, and I guess I would react to, I guess Bernie was quoting Lynn Goldman, another author, "Science without policy is still science." I guess I don't believe that. I would say in these matters, wherever the results matter, wherever uncertainty combines with the real balance between lives and dollars, there is no science without policy. And I think we're better off admitting that. I think we're better off saying that every step along the way, even things that we think are innocuous, like the p-value or how confident we need to be that something is causal or not, inextricably reflects an underlying way of looking at the consequences of error. And I talk to people all the time who I know in my heart have a very different view of the consequences of error than I do. But you know, Tony Cox, for example, weekly for 40 years will say, "I'm value neutral, just the facts, ma'am. I just have a test for causality." He refuses to admit that his test for causality has real world consequences. I think we're better off making everyone understand that you can't be value neutral, and that's a good thing.
Bernie?
Okay, so when we respond to Doug first, I think his point is a really good one about the difference. Let me point out that those bell-shaped curves I gave you, I purposely gave that toward a relatively mature issue such as ozone, where there might be 1,000 qualified scientists out there who are really knowledgeable about it, and literally thousands of papers that have been published. PFAS doesn't fit that. There's a relatively small literature. It's relatively controversial. I'm not going to say who got the controversy right because I haven't really looked at it in any detail, but it is not unusual as you go through this type of process that you end up with these kind of differences. And really, they serve as almost a research needs discussion. Adam and I are just defining science differently. Adam, I use the axis of basic and applied, I mean, if you will, as how the way I'm reading that science. And right now, I didn't have time to put it in, but there is a supplemental approach to the transparency and quote unquote secret science bill that just came out of OMB, and it is going to have a hearing. We have until April 15th to respond to it, where basically they expanded dramatically the amount of science that they're covering. So that where the initial act just said dose response type of studies, now it's basically almost anything, including some of the basic science that underpins the biological plausibility part of an argument that PFAS or compounds like that are in fact harmful.
Okay, great. Thank you. I insert a little editorial. I mean, in the middle of the virus crisis, it is interesting. I think Dr. Fauci and all those scientists that we hear at the mic are really only at the mic because the president allows them, and the president is in charge of what the agencies do or his appointees. So, I mean, I'm glad we're hearing from the expert community, but I think it's only it doesn't have to be that way. We could just be hearing President Trump's view of what we should do scientifically as a nation, technically, or his appointees. I think that's right. Anyway, just my editorial comments. If we have 1 minute, Jonathan, I also was interested in this interface between state and federal, sort of discussions about setting health protective standards. Again, in a way, Doug sort of raised that with the differences. This is probably good because we have a whole bunch of different views, or how do we line this up? I mean, or does it start to become sort of mass legal health protective standard chaos?
Well, that could be a very important point that comes to fruition. One of the points that Bernie identified is that we really don't have a lot of data out there on PFAS. That happens with a lot of the environmental health issues that we have to deal with. We still have to do policy on it. And, you get a situation where EPA, the states, industry, everybody comes up with incomplete data because we just don't know what the long-term impact are. And PFAS is a very good example because in 1960, this looked like the wonder chemical. And in 2020, it is, one of the more problematic chemicals out there. And we now have to figure out how do we have to address it. There are going to be different points that come in. I think one of the points that I'm seeing is that, as Bernie has identified the limitations that have come up to EPA, that I'm seeing less and less respect emerge for EPA standards because, people are questioning it more and more. Are these legitimate? Are these science-based? Is this something that is really, really unbiased data that we're dealing with here?
A very good point. I couldn't agree with you more.
I guess that's a nice note to end on and also be on time. But thank you three. Those were outstanding presentations and they fit together beautifully. Thank you.
Thank you very much.